opportunity.
Okay, I have a question, and it's kind of touching on what Ron was saying, but is there a difference if you're called in just to be a witness, or if you're actually being indicted? Is there a difference when you're in front of the grand jury? As far as, okay, we were called in as witnesses, we weren't called in on our own behalf.
As defendants.
As defendants. So is there a difference if you're a witness or if you're a defendant as far as how it's conducted? I mean, as far as the prosecutor asking us questions and us answering the questions, or?
Either one can claim the fifth, or you can answer the questions.
Can you demand that he sit down and not ask her the question if she's just brought in as a witness?
It's my understanding that the grand jury is the ones conducting the interview.
That's
not
supposed
the prosecutor.
to be, yeah.
Prosecutor. Prosecutor made it quite clear it was his job to ask the questions. The grand jury was just there to make a decision on whatever they were going to make their decision on. But we did take the fifth, and then of course we were hauled in front of the judge to either go to jail or get a lawyer. So those were the only two options at that point.
Turn over the books,
Or turn over.
turn over the books, or you'd be in contempt of the jail.
Oh, I'm glad you brought that up.
So my question is there a difference if we are called in as a witness to answer their questions, or if we're called in as a defendant where we can draw the line?
You have the ability to draw the line, I think, in any situation, whether you're a witness or a defendant.
So our question should have been directed to the grand jury, because I do know that it was grand jury's decision to send us to the courts because we wouldn't do what they wanted us to do. So it was up to them, the grand jury foreman, to make that decision, not.
You have to understand that the grand jury is not a pack of legal geniuses or law professors. So they can make mistakes about the law. I mean, you might be in front of a grand jury where the entire grand jury believes that you have to pay your fair share. They may also believe in Santa Claus and Easter Bunny. Who knows? But if you can come in and present stuff, Supreme Court cases, and whatever else that you relied on to make your decision, I mean, they may change completely, you know? So, anyway, the point being is that you have the power. And when the judge says you can do this, it's the green death bill or the blue death bill. You say, no, I'm going to take something else, you know? And then Ron spoke up, or Desi, was it Susie, or anyway. I'm going to. The point is, I had this flash, and I got to tell you real quick about this one.
Can you say that we have 2 more minutes for the tape?
Okay, break time.
Yeah, we can take a break.
Take a break would be good.
Remind yourself of that. And I wanted to quickly address what she just said in the last minute here. There was a reason that the attorney turned to the jury at the end and said, do you have any questions? It's called due process of the jury. Okay. So therefore, he had to do that. Everything that happened before that was procedure, which means he could have claimed anything because he made a statement and he asked the question, hey, what is your authority to ask me questions? Can you please cite your authority? He would have fallen silent.
Right.
Okay?
Okay. Okay.
So Martin goes and he uses some of this money for his own personal stuff. Then a woman comes in and she has a large amount at the account and she wants it all out right now. And there isn't enough. So whatever happened there, she took the complaint to the federal authorities. And Barefoot Sanders, the same one that decided with me on the State Department case. Barefoot Sanders was handling the case, and Martin was brought in, and Barefoot Sanders said, "You will produce the books and records of your private banking operation." And Martin would not produce them, so Barefoot Sanders put him in civil contempt for 180 days. Okay? At the end of 180 days, he brought Martin back in the courtroom and said, "You're going to produce your books and records now?" Martin said, "No." Another 180 days. Brings him back into court again. So you're going to produce your books and records now? No. Another 180 days. Well, how long can this continue? 3 times. And so he put him in 3 times for 180 days. And Martin never gave up his books and records. And you know what the end result of that civil contempt was? That's right. Martin and his girlfriend hooked up and they went to San Antonio with a bottle of champagne. If he had given up his books and records, he probably would have gotten a very serious prison term. Now, I'm not saying that I recommend anybody do that. I mean, what Martin did was not right, and the Bible, of course, would call that theft, because he basically stole that woman's money. But I'm just explaining it to you so that you understand that civil contempt operation. And if it ever came to it, that you know that one option, that you could do 180 days 3 times in a row, and then it's over. Now, Susie didn't know that at the time. She did a bunch more than that. But that's against the law. And I believe that you got them for holding you beyond the legal limit.
Well, I couldn't find, in all the research that I did in the code books, I couldn't find any specific, I take that back, I did find 3 specific time frames. One was 30 days, one was 90 days, I believe, no, 6 months, and then 6 months, and then the next one was, no, I think that's all it was. There was just a 30-day and a 6-month time frame that they could hold you. And I brought that up to them. And she just said, "I don't care, put her back."
Yeah, well, they can do that, like I said, 3 times. 3 times 180 days.
Is there a lot longer than that?
Okay.
When you talked about a criminal contempt, okay, you explained some of the rights that you had: due process, witnesses, fix your accuser. Does that have to do with the fact that in order to have a criminal complaint, you must have wronged a party? You must have caused damage to a party?
Injured.
Is that related?
Could be.
Because I know some people have said when a judge says, well, when you ask, is this criminal or civil? And he says criminal, I say, well, who is a party that I've damaged? You ever heard that say?
Yeah, that's a good point.
Is that the reason that you're entitled to your due process? I'm trying to make the connection.
Well, you're
Because-
entitled to due process if it's criminal.
That's why I said criminal.
Yeah.
So if you asked him, what contempt am I being held on? He said criminal. And you said, well, who is the injured party? Okay, having them identify the injured party.
Yeah.
Okay, like any other criminal act, if you do a criminal act, you've injured someone, okay, or you violated a statute. If he can't do that, then say, then why are you confining contempt to a criminal charge? So I don't know. I'm just asking a question. Trying to draw a correlation.
Okay. I don't know what to say. I mean, if it's criminal contempt, you're entitled to everything that would be involved in a crime. So that's all there is. Okay, so then you after you go to trial, if you get convicted, then comes allocution. And as I mentioned earlier, Robert Ford wrote in his book that everyone who goes to prison is there voluntarily. important not to volunteer. So, Rule 32 in the federal criminal rules says that the court, you want to read it? I got it. Huh? You found it?
From yesterday,
Well, how about going to the microphone and you read it?
And that was section opportunity, under opportunity to speak. Section A, by a party. Before imposing sentence, the court must, I, provide the defendant's attorney an opportunity to speak on the defendant's behalf, double I, or the number 2. Address the defendant personally in order to permit the defendant to speak or present any information to mitigate the sentence. And 3, provide an attorney for the government an opportunity to speak equivalent to that of the defendant's attorney. That's all of subsection A. Do you want me to read subsection B and C?
I don't know what's there.
Dealing with by a victim, opportunity to speak by a victim or in-camera proceedings.
Oh, okay, yeah, they could bring in the victims to whine and cry or whatever. But the important part is that you get to speak at your sentencing. Well, a lot of people think that when, after the trial and the rest of that, and it's sentencing time, they think that the judge just says, well, you get 10 years, and that's it. But it's important to know that they have to ask a question and that you have all the time that you need to answer the question. And even if that takes hours. And because if you've got information to mitigate the sentence or a statement to make, you're entitled to do so. And if you can say the right stuff, you can win the case right there.
When you mentioned earlier that in order for the document to be legal, that it had to have the attorney's bar number. So with a warrant, a search warrant, shouldn't there be a case number on it in order for it to be a legal one? And also, what's the best way, if it's not, to stop them from the harassment?
Case number on the search warrant.
There's a spot for it.
Yeah. Well,
There should be one. There's a spot for it, shouldn't there be one?
yeah. Okay.
That package should, I don't know if
Yeah. Well, this is the search warrant, but this is different than the indictment. The indictment, requires their bar number because the grand jury is not a part of the government. And if the attorney is going to sign the indictment document to bring it into the case, he has to affix his bar number. That, see? Here's the grand jury foreman's signature, and here's the signature of the U.S. attorney, and then the assistant U.S. attorney, but no bar number for either one of these. This is trash, because they're not taking responsibility for bringing this into the court case. Well, I haven't looked at all the details of that one, but that's different than the indictment. And as far as getting them to stop harassing you, how many times have they done searches?
They've done 3 in the last 2 years, and
Each time it's been about them looking for somebody who doesn't even live in my home.
Well,
Like friends of my son's
got grounds to sue them.
I know, and I'm so scared because of the fact that they always retaliate. And I'm by myself, you know what I mean? Ever since my older son has gotten in trouble, I've been harassed. My younger son has been harassed. And I know, once I start fighting back, I'm gonna have to move. I'm gonna have to hide somewhere because they're gonna be retaliating and you know, it always says on the search warrant, single parent or single family dwelling or whatever. They know I'm there by myself, and they know that they've continued to get away with it, so they keep doing it. Another thing, they keep taking my property, stealing stuff, and I was gonna ask, is it best to put a sticker on your computers and stuff that says evidence, or is it better to put something on it that says, least two? What's the best thing to put on your stuff to keep them from taking your stuff?
10,000 volts.
That would be the best idea. But, I don't know how to answer that one. You probably have to pray about it. And this is, some people understand this and some don't. I'm hoping that you do. You can call on our Heavenly Father. And he says in Jeremiah 33:3.
Call on me and I'll answer and show the great mighty thing which thou knowest not.
Exactly.
And it's his telephone number.
That's his telephone number, exactly. And Jeremiah 33:3, it says, call unto me, I will answer, and show you great and mighty things thou knowest not. Now who's talking? It's our Heavenly Father. This is his book. He cannot tell a lie, and he has all the power in the universe.
Amen.
He can whack them like they've never been whacked before. And you can ask him to do it and show them their ways. I just feel it on my heart right now to share with you that in Psalm 91,
10 and 11? 10 and 11?
Psalm 91,
10 and 11. 91, 10 and 11.
the verses,
Yeah.
okay?
There shall no evil befall thee, neither shall any plague come nigh thy dwelling. For he should give his angels charge of thee to keep thee in all thy ways.
Right. Well, but here's the point I was going to get to about Psalm 91. First off, there have been books written about it. Books written about one psalm, Psalm 91. Now, if you read it almost through the whole thing, I didn't mean to run away, Mark. You had a question?
Are you talking to me? No.
Okay, so Psalm 91, if you read it, 75-80% of it is talk, important talk, but just talk. And then you come towards the end and it says, I will. Well, now that's different. Because that's not ordinary talk. When he says, I will, that's getting serious. Okay? So, World War I, there was the 91st Brigade. Chaplain that made out cards with the 91st Psalm on them, handed them out to all the troops, and got a commitment from each and every soldier that they would read the 91st Psalm every day. And they were in 3 of the bloodiest battles of World War I. Casualties to their left and to their right on their side of the line were running at 90%. Casualties for the 91st Brigade, 0.
Amen. Hallelujah.
Amen.
And, in the rec yard at the Cherokee County Jail, I talked to other inmates, and they understood that. And they were doing the same thing, calling on our Heavenly Father. And Cherokee County, as like you say, is so rotten. Other guys I met in the rec yard said, Fox, Anybody who bucks the system in this county, they'll handcuff them to a tree and use them for target practice. And I'm still bucking the system. I'm not looking for being used for target practice, but I'm calling upon our Heavenly Father for protection. And, you know, your situation, it strikes me as being that kind of a situation. And he can't tell a lie, and he has all the power in the universe. And there's some things that, you know, some things that are difficult to decide, like what you're talking about. You know, which way do you do? You could do both even, but, you know, label things as evidence and be least. There's all kinds of stuff. I mean, I'm thinking that the trespassing sign, you know, different things that can be done. But the most important one is to call on our Heavenly Father.
Amen.
May I approach, Your Honor?
Listen, this guy is so good with his jokes, and he's such a quick wit.
Thank you. Most of us would not have to take these, let's say, fringe approaches had there been justice in the courts.
Right.
It appears that they expose themselves to loopholes that they themselves keep for their own. And if we figure out those loopholes, we may stand a winning chance. Unfortunately, not everybody has the time and the dedication to perform that which you do and others in the same venue. Going back to the point you were making earlier in regards to allocution, you said that with sentencing, you can re-invoke and resummons the witnesses. And that's a strategic move, and it's a valid one. The question I have in this particular is do you use a particular, you no longer put motions into the court. How do you bring the witnesses at time of allocution or at sentencing?
Okay, well, I could send you how I do it.
Make a note.
Make a note.
Send all the files.
Those, like hacksaw type files.
But write it with the right hand this time.
Okay, so you do have an affidavit, and you declare that you need these witnesses and that their testimony is material and relevant to the case, and if you want them to bring certain things, if they have them in their possession, they have to bring them. And you write all this stuff up and you give it to the clerks. And the clerks put it on the subpoena documents. The clerks put on the raised seal or printed seal or something. They got some kind of seal that they put on the document. And then in the federal, it goes to the U.S. Marshals for service. In the state, it'll go to the Sheriff's Department, and they handle the service, and there's no provision for them charging you a dime for it. Okay? You should be able, they should do almost all the work. You just give the order of who and what and when, and they should be in lockstep and get it done.
Let's
Of course,
say,
you have to give them enough time.
right, so let's say the sentencing is 30 days.
Well, you should get your subpoenas in as early as you can.
You get the subpoenas from the court.
Well, you can, and you could write them up, and then they could put the seal on it and hand it to the U.S. Marshal, or you could create a document and provide them with that information. So in the federal, I think in some places they'll just give you the subpoenas. You make them up, but you have to pass them back to them, and for them to turn it over to the U.S. Marshals. Okay? But in the state, it's always been my experience that you can just do it up and, I mean, your list and what they have to bring and so on. And then the clerks type all that in their own stuff and create the subpoenas and give them to the sheriff to serve.
In your experience, this takes about what, a couple of weeks?
Depending on how many you have, they put clerks on it and they try and do it real fast. Most of the time, I can get the subpoenas if I have them in there 8 or 9 o'clock in the morning. By closing time, I've got them.
What would you do in the case that an original witness was refused from being brought forth as a witness by the court?
Well, see, this comes to the power of your affidavit, and you declare that this witness is material and
Gotcha.
relevant to your case, and is done, notarized under penalty of perjury, and who's going to argue? I mean, they need to have a counter affidavit. They got to have a hell of a good reason why not.
And you can email that affidavit to me so I can email it to everybody else, right?
Yeah.
Okay, good. I got connections.
Well,
Got it.
I made a note here, so I sent it out to everybody, and everybody will have it.
I have a question regarding the allocution process also. Is it my understanding that regardless of what argument you come up with, whatever reasoning you give as to why, this isn't fair, why this person lied, this person did this, here's proof that I'm not guilty of whatever crime you're being accused of, at the time of sentencing when the judge says, I'm recommending that you be sentenced for 10 years. If I continue to say I don't accept that sentence, does it matter what I say prior to? Is that just something for the court to see in terms of like we're putting on a play, or is it actually something that needs to be relevant?
Okay. They'll stop you if you start talking about Santa Claus and the Man in the Moon. It's totally irrelevant. But stuff that's relevant, you are setting the record, even if you're dealing with a judge that's an absolute bonehead idiot, like Judge Bentley that told Dr. Barry Brooks. I don't think the Supreme Court said that. Yeah. So even if you're dealing with an idiot, you're preparing a record that goes forward to the appellate court, or and by the way, a lot of people don't know this one, and this is what we raised in Tim and Dawn's stuff. The appellate court has two functions, and appeals is the main one that gets used. The other one is used so infrequently that they may not even understand it when you send it in. But in Tim and Dawn's case, they have not, prior to any sentencing, we were already sending documents to the appeals court. But on the envelope we put that this envelope contains only file stamped court documents, and that it was for the purpose of supervisory authority. See, they have supervisory authority on the courts below them. And this was not an appeal, but this was to show the court, the appeals court, that these guys at the trial court were running outside the legal limit, denying due process, doing all kinds of crazy stuff. And these were not, the important part about that these are file stamped court documents. That means it's all public record, and we're not dealing with ex parte communications, like as in This envelope contains no ex parte communications, only court documents that are file stamped. So it's in the public record already. And then the purpose of this thing is to invoke supervisory authority. Is that interesting?
Yeah.
So you can be rattling the cage at the appeals court while your trial is still going on. You like that one?
Yeah.
That's the equivalent of an interlocutory appeal.
Yeah, well, they'll try and block you on that interlocutory appeal.
Right.
But interlocutory appeal is another way of doing something similar
From a different angle.
from a different angle, yes.
I have 3 questions. In Pennsylvania, or one state, and New Jersey as well, when you have, let's say, for instance, a ticket, they found you guilty, you have to appeal. And when you're appealing, you're actually appealing to the criminal court.
Yeah, they are criminals.
That's what they are. Now, for the subpoenas, you said we didn't have to pay anything. In Pennsylvania, they're charging for the subpoenas to send them out.
In a criminal case?
Civil.
Oh, well, yeah, in civil they can charge,
Okay.
but not in a criminal case.
Okay. Now, when the judge actually enters the plea for you, let's say you tell him or her, you do not plead. I have seen where they have actually entered the plea for people who
Right.
said they don't plead.
If you refuse to enter a plea, they'll be authorized to enter a plea for you. But if you say, I'd love to enter a plea, Judge, I really, really want to enter a plea. However, I don't understand. And my good friend Perry Mason didn't show up today, and you could plainly see I'm without legal counsel. And that business of being without legal counsel stopped them dead in their tracks every time. Or I shouldn't say every time, because you can run into a real bonehead sometimes. And, but they're slaughtered if they proceed when you say, I need legal counsel, and they say, no, we're not going to do that. Like Jerry Buckmeyer did with Don McCarley. When Don McCarley said, I want Robert Fox as my assistant counsel. He said, no, Fox is not an attorney. You can't have him. You're going to represent yourself pro se. And then they lost the case, and Don McCarley walked right out the front door at his sentencing.
The statutory authority for that is Federal Rules, Rule 11, when it says you have to plead. If you're going to plead, there's only one plea under which they have to check that you understand the plea, and that's the guilty plea. If you take the guilty plea, they must make sure that you understand the charges. They cannot move if you do not refuse. Operative word is refuse. So as long as you do not refuse, they cannot move forward. We were able to postpone arraignment 7 times on that issue. However, it does fade away because at a certain point the judge figured out, oh, okay, they're after the statutory legal to where you have to, I forget the term right now. Expedient to the trial. Speedy trial.
Speedy trial.
Statutory speedy trial. And he put a time clock on it and said, look, we are doing this for you, so you can't push this beyond the speedy trial. So you can play it for a while, but eventually they'll do their game. So that's why I call them a little bit of fringe solutions to some degree. However, everything that I've heard thus far, everything that you have to say with the keeping them at their own rules seems to work the most. Where I think Carlo has mentioned that if you point out that which they don't do, then you don't have to prove anything because they already didn't do it. and by not doing it, still considered an agency or an officer's action. That which you're supposed to do is still an action as if it was done. The not doing part, and is just as incriminating upon his actions as if it were an action against you, but you don't have to prove anything because he did not prove by not doing it into the record. And that seems to work with them. That's the point I wanted to make.
Thank you. So, at elocution, some people have been able to defeat the thing because of their procedures or the facts of the case. There's all kinds of stuff on that. But even when everything is against you, like my friend Ralph Gergel, and it was a misdemeanor, and it was maximum 6 months and $4,000 fine. He told him right up front, he said, I have no money. So they dropped the $4,000 fine. And then they wanted to give him 6 months. He said, no, I can't do that. And they said, well, how about 3? No, I can't do that. 2? No, can't do that. 1? No. It's a week.
Why do you even settle for that?
Well, he would tell you if he was here right now, or you can call me or patch him in on the phone. His comment was that he probably could have talked him down to 0, but he was,
You don't want to push his luck.
he wasn't 100% sure, and he was like tired of arguing with them, and so he figured he'd do a week and be out. So that's what he did.
A week or a weekend?
A week. I think he was there 6 days and they threw him out.
Got out early on good
Was this-
behavior.
Huh?
Got out early on good behavior.
Yeah.
Was that civil or criminal?
Criminal.
Felony or?
It was misdemeanor B in Texas. Maximum is 6 months in jail. And they wanted to give him the 6 months, but he talked him right down to 1 week.
Simply by not accepting.
Yeah, not accepting. He said, can't accept that. And you can soften it if you want. You can say, Judge, with all due respect, I can't accept that. And you can give them reasons or not give them reasons. And, their whole system is voluntary.
You need to get Judge Work's book, huh?
Well, you could, but it has to be the first edition, because after that, it was deleted.
Really?
Yeah.
What if,
But you may be able to find one, they sell used books on the internet. The Tempting of America. Robert Bork. B-O-R-K.
He was born in town.
so what if a person is guilty of a felony? And it comes down to execution. And he just says.
are missing the boat
I'm
back
not
there.
guilty.
Microphone.
Microphone. Sorry.
What if he gets to the point of allocution, and he says that I'm not guilty, and he just stops at that, and he said to 10 years, can he just say, I don't accept it?
Yeah, that's what I would do. I would just say I don't accept it. And, like, with all due respect, I don't accept it. Of course, myself, I wouldn't go looking to do a crime in the first place. That doesn't mean much to them. They have a revenue enhancement program like Blackbeard the Pirate.
What is the name of the book again?
The Tempting of America by Robert Bork. And another one that you need to get is Confessions of an Economic Hitman by John Perkins.
Yeah, that's a good one.
And of course, you need, where'd my US government manual get to?
Right here. I don't know.
I've never even seen it. Right there.
Well, and it was being passed around for everyone to see that I
We
wasn't,
always overlook.
Yeah, everybody saw it, except
except Gregory. He said everyone saw it
except you.
except Gregory.
Right, right.
We didn't see.
Amazing.
Gregory was on
How
a
come it didn't get
cigarette.
passed around?
It got passed around. We did. Went all the way to the back.
Mike was hoarding it.
Moving on. Yeah.
I have a question. In this allocution, when the judge is giving you a sentence and you're kind of like negotiating or saying, I can't do that. And you get down to a point where, you know, he says, what about, 2 years? And you still say no, and he said, too bad. Okay, go over and sign the papers. Okay. When you walk over and sign the papers with the clerk and you refuse to sign the papers, doesn't make a difference what the judge said until you sign the papers, right?
Well, that's another good point. That would be, not signing the papers is gonna throw a monkey wrench in their gears. And I haven't covered this point yet, and I need to right now. Okay, so at least I don't think I did. You tell me if I did. When they get me in the jail there, and it's like empty your pockets, okay, 5 pens, a comb, set of keys, such and such cash. They count it all up, they write it all up, and they say, sign here for your property. Tell them, no, I'm not signing. Did I cover that?
No.
Okay, I tell them, no, I'm not signing. So the jailer says, well, don't you care about your property? So let me see if I understand this correctly. If I don't sign, that makes you a thief? Okay, and I don't sign, and they put that property away as secure as they do anybody else. And then when it comes time to leave, they say, they pass me the paper to sign here for your property. So I didn't sign coming in, and I'm not signing going out. They still give me the stuff.
Was any of it missing?
No. Did have one time trouble with at Dallas County Jail because I had gold coins and they didn't put them with the property. They put them in a vault, and they had them, how should we say, more secure. And when I raised the ruckus about the missing gold coins, he said, "Oh, those are in the vault." Like the head cheese jailer had a vault, and they had to get him to open it up and get him out.
How many of these people are bad? How many are good percentage-wise in your own experience?
Mostly bad. Okay, I've got a couple of friends. Brady Byram worked at the Dallas County Jail for 6 years. The other guys told him, because they knew his attitude, and he didn't go along with them beating up prisoners and stuff like that. And they just told him, since you don't want to toe the line with the rest of us, you're going to have a Serpico type event.
What?
A Serpico type event. Do you all know who Serpico was? Yeah. I mean, a true story of a cop that was straight, and the other guys set him up, and the druggies put a round through his head. Fortunately, he survived. So, and he was set up for that. They could have stopped that, but his partners didn't stop it. They put him in line to set it up to get him killed. And that's what they threatened my friend Brady with at the Dallas County Jail. I have another friend, Lewis Moore, who was 5 years on the New Orleans police force. And his comment was, anyone who's there any longer than 5 years is totally corrupt. He said, new guys they come in and they have these ideas that they're going to arrest the bad guys and help the good people. And thank you. They're going to arrest the bad guys and help the good people, and so on and so forth. But they get swallowed up into corruption. And, once they start taking bribes and stealing drugs and all kinds of stuff, it's just downhill. But every once in a while you run into a nice story. And I have a friend named Chuck, who's a Marine, a former Marine, and he was at a bar in Richardson. And he went out to his car. Now, we don't know what he went to his car for. It could have been to get his cell phone or business cards or something, whatever. But as he approaches his car, and he's just about right there, he gets slammed from behind, and there are 3 plainclothes Richardson detectives who never said a word, and slam him into the car. And Chuck doesn't know what's happening. All he knows is that he's being assaulted. He turns around and whacks one of them in the Adam's apple off to the hospital. He kicks the other one in the nuts off to the hospital. Side kick to the third one, breaks his knee, off to the hospital. And then uniform cops arrest Chuck for assaulting officers. Okay? Well, at his trial, there were witnesses. The witnesses from the bar, a businesswoman from across the street, and it was brought out that these detectives never said a word. They never said, we're police. They never said, you're under arrest. They never said, stop. They didn't say anything. They just slammed Chuck against the car. And for all he knew, it was a mugging or an attempt on his life for unknown reasons. And he was trained in the military, and he knew how to defend himself, and they tackled the wrong guy. And he chewed them up. And those detectives, by the way, were all fired from the police department.
Good.
One of them said to Chuck that they were going to get him, and he said to that guy, he said, at 1,000 yards, I can take the tip of your little finger off. And he said, you won't see it coming. and so, and he won $140,000 on it too.
Good.
I hate to admit it, but we're gonna run out of tapes. We didn't come prepared enough for
Well, we
you.
got that one.
Is there anything, we are. Is
No,
there
we got-
anything
we
on
got
your
40
list that
we
we
got
didn't
45
cover?
45 minutes on this one left.
Habeas focus. Have we seen, did we cover everything on your list? Or can we squeeze any more out of you?
Well, it's up to you. What, you
did-
want to stay for a few more minutes?
Did you
want
cover
me to talk
everything?
about habeas corpus for a few minutes?
Yeah,
Right.
yeah, what is habeas corpus exactly?
Okay. Habeas corpus. Well, there's a part in that stapled. How many pages was it? Was it stapled together? 11 pages.
10 on that one.
10.
There were originally 11, but you'd already given them one, so there's 10.
Okay, 10. There's one in there called, it is William Penn. And that talks about habeas corpus. Freedom for William Penn. Anyway, that was a story that can practically bring tears to your eyes. Anyway, there's a multimillionaire in Dallas, Ken Evans. He had a ruckus with a judge, and he sued the judge, and her friends who are judges, one of them put Ken Evans in the Dallas County Jail, and because Ken Evans is a multimillionaire, he could hire any attorney in the country. Instead of calling an attorney, he called me. And the net result was a unanimous win at the Texas Supreme Court. In the time he was at the Dallas County Jail, he had a sign up on the wall at the door of his cell, and it declared that he had been kidnapped and that they were his kidnappers. And the jailers laughed at that. But Ken said that the day that the order came down from the Supreme Court of Texas, and that they escorted him out of the jail, he said they were shaking. He said that they were traumatized by this event.
What was the story behind that?
He had sued a judge, and to retaliate against him, they put him in the Dallas County Jail. And the stuff before that goes like this. He had lakefront property, a beautiful home. His wife was the one who read all the MRI scans at Parkland Hospital. She was like even not just a doctor, but the supervisor of other doctors. And Parkland, of course, is where they took Kennedy when he was shot. And anyway, between Ken and his wife, they had considerable wealth and lakefront property. Okay, so there's a lawn right to the lake. Okay, and he has grandchildren. Now, in Texas, there's things called water moccasins.
Those are snakes.
They are poisonous snakes, and Ken had a concern for the grandchildren that they could be playing in the backyard and not paying attention, and especially with the grass, the snakes blend in. The next thing you know, you're snake bit. So what he did was he built a redwood deck, at the back, not covering the whole yard or anything. It was a redwood deck, and he wanted to tell the children to limit their playing to the redwood deck. Well, somebody complained or whatever, and code enforcement told him he had to tear it up, even though his neighbor had one like that. But he had to tear up his. And so he took it to court, and the judge just basically stomped all over him. He was pissed, so he sued the judge, and the retaliation put Ken in the jail. And their stuff was defective. I took a look at the file, and I saw what I saw, and I knew it was defective. I went to the phone and called a businessman that I knew that was not too far away from the courthouse. And I said, would you please come down? I need for you to witness what's in this file. He came on down. I showed him the file, and he took notice of the defect, and then he and I both did affidavits. And this is an important piece that I might have missed. Deuteronomy 19:15. At the mouth of 2 or more witnesses, so shall the matter be established. So when the police say Mark was speeding, if there's two or more of us, we'll sign affidavits. You know, we were in the car, he was not speeding. Valentine's Law Dictionary, the two-witness rule, our two affidavits overcome the police officer.
Would that also overcome a form enforcement thing?
It'll overcome anything that, you know, when you apply the witnesses to it. Let me give you another for instance. In Texas, we have a bystander's bill of exceptions. The way this works, you're in court, stuff happens, the court reporter's taking it all down, right? And before the transcript comes out to you or any of us, the judge looks at it. Okay? And the judge says to the court reporter, take out this, add that, change this. Right?
Right.
And if those who have been around long enough know that this happens, that transcript gets modified. And that's against the law, but it happens. And the clerk doesn't like doing it, but the clerk's bread is buttered by that judge. Okay? So this is the way it goes, and they present to you a transcript that's been changed, tampered with. But in Texas, a bystander's bill of exceptions, 3 affidavits, overrules the court reporter.
Can I ask a question? If I go into the courtroom and carry an illegal tape recorder and tape the entire episode in the courtroom, and I get the transcript and it doesn't verify with what I've recorded, can I bring my tape recording forward and say, look, I illegally taped that proceeding, you can probably throw me in jail for it, but they falsified, the judge had the clerk falsify the record here. Who's the crook here, me or them?
Well, before you go to admitting anything like that, I would say, I accidentally recorded this.
So the recording would work against them?
Well, the thing is, this is what I was explaining with Dwight's case. Dwight had me bring the recording of the telephone conversation with Werner. And they didn't have any problem with the fact that it was a tape recording of a telephone conversation. And I was going to testify to it, that this was me on the tape, this is the words that happened, that the tape was held completely secure, it had not gone to anybody else's hands, and was exactly the tape recording that I made. So you've got to have a chain of custody.
Right.
And I said, it's always been in my custody, and I'm the one on the tape, and I can verify that this is my recording of my conversation with Werner. And I was there to do that, and there was nobody had a problem with the issue of the tape. Jerry Buckmeyer stopped me because of the issue of the oath. But that goofy guy, they ended up having to apologize at the Fifth Circuit Court of Appeals.
I was going to say, before doing that, you need to take the transcript to the court reporter and give her the opportunity to correct it first. I had that done to me twice. There was one time, it was a traffic case. The judge tried like 9 different times to get me to cross the bar. I wouldn't. When I got the CD back, it only had it maybe twice in the beginning. And there were other parts of it cut out. And there was another case that I got, another transcript that I got. There were 3 things that I needed for appeal. All 3 of those things were gone. So that was what I was told to do, was let the court, give the court reporter a chance to correct it first, because they sign under penalty of perjury when they do those transcripts.
Right.
So do that first and then go to the next step.
But then you don't catch them in the act.
One other suggestion, I know that in Susie's trial, you had people who were witnesses to that trial. They sat through there every moment the trial was going on. There's, I know, at least 3 or 4 myself that were in that courtroom. You may invite them down to your house
Play the tape.
and play the tape and refresh their memory,
Then they
and
can
have them do their
They
affidavits.
took shorthand every day.
Well, have them check their notes and do
Their notes
affidavits.
of the transcript.
And if they're a little bit sketchy, then just have them to share your favorite music on the radio. Take that.
don't admit to the tape.
Were there things different or just missing?
The best suggestion I've heard is just to hire your own recorder.
Yeah,
$500
Hire your own recorder, rather. I'm sorry.
yeah.
That's very costly.
A lot of judges won't allow you to bring your own recorder into the office.
Because it could be the judge too up front, because they control when it's being recorded or not. And this actually could have been the judge's own doings versus the court reporter.
Yeah, he has a hold of the button.
So he may have actually taken me off the record different times.
You know, they try to
Actually,
prevent you from bringing a recorder into the building, but I've never once heard a judge say to the audience, if you got a tape recorder, turn it off. I've never heard that.
Oh, be careful. Federal court, it's a crime.
Is it-
Oh, yes. I found out.
He found out.
I got
But
lucky.
you know that they do have now, it's a spy shop, and you can get a recorder in a pen
I had to watch.
and or a watch, either one.
We recorded the entire trial.
You can get them on cell phones too.
And the judge found out about it off the internet because we went to Richard Cornforce meeting and Richard said, everybody ought to see his watch. And they put that up on the internet and the judge heard it. And the next time I was in that courtroom, I had to come up and talk to the judge. I'm lucky I didn't get in jail for contempt. That's what he would have done. So it's not anything to fool with.
Well, some of the people are already leaving. I guess
Habeas corpus.
habeas corpus. What else to tell you about that? I could send you a sample.
Make a note.
Make a note. Make a note.
This is a whole file.
Send everything.
Wouldn't that be easier for you?
The one I'll send you is of where I made a change in the style that I was doing things. You know, normally I did the habeas corpus. You have to say some stuff up front. It's important stuff. You have to declare what the case number is, the party, what the issue was, so on and so forth. You know, and how long they've been incarcerated, where they're currently incarcerated, because the habeas corpus is directed against the holder of the key, which could be, you know, to the cell, which could be the chief of police if it's a city jail, could be the sheriff if it's a county jail, could be the warden if it's a prison, it could be whoever is with the Bureau of Prisons, the warden, or it could be U.S. Marshals, you know, but whoever it is that holds the key, the habeas corpus is directed against them. And there's a couple of different styles. If it's the prisoner himself doing it, it's ex parte, and if it's somebody else, it's ex rel, you know, for the people of the state, on behalf of, and then name the prisoner.
Would you have a habeas corpus already written at time of allocution, should allocution be denied, and moving forward with sentencing and
If you got
calling?
time, you can do it in advance, yeah. Anyway, the change that I made with the habeas corpus for Nicole, is I put in a section that I call preview, and I've never seen anybody else do this, but I put in preview, and I hit them boom, 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 right away in bold print. And like I mentioned earlier, things that scare them are embarrassment and liability. So when they looked at this preview, that's what they saw. And like I say, it arrived in the clerk's desk at 1:05 p.m., and by 5 p.m. she was on the street, and she said they didn't even want to let her finish her meal, and there was no hearing, and there wasn't any exchange of documents. They took one look at that, and she was out. Go ahead.
My question is, when they arrest you and they're shipping you from one state to the next, how do you handle that in reference to the habeas corpus?
Okay, first thing is that the process you're talking about is extradition. And all extradition is a federal matter as such, and there's a case, and I'll have to mark that down to case laws. It was Bozeman versus Alabama, I can't recall. But anyway, they have a limitation, they have a time limitation on them. And typically people just give up and allow themselves to be extradited. But you can fight extradition and prevent them from taking you. And if they don't take the right actions fast enough, you can beat the whole rap. They got, this case talks about their time limitations to do the extradition. And it's a federal matter. And so, you might have a state issue, like say you're here in Arizona, but they want to extradite you to Pennsylvania. You may be facing something serious in Pennsylvania, and if you could stay in Arizona long enough, they will not be able to take you. So, you could fight extradition. You could do a habeas corpus in that fight. You could do all these things. And I know of one fellow, he spent 276 days in jail, and they were, best I can tell, way beyond the limit. But he had just become aware of the stuff, the limitations. And I think the limit is 120 days, if I recall. Anyway, the day came, they just let him out and let him go. The jailers came to him and said, "You're out of here." He was gone. And the other state, kiss off. Habeas corpus. You want me to share one more little story on habeas corpus?
Yeah.
Okay. The mother and the aunt came and shared with me that Ron Gradle had been harassed continuously by the police. And in his past, he had been a drinker, etc., DWI stuff. But they shared with me that he had completely given up drinking, but the police had not given up harassing him. And so they had him in the Tarrant County Jail, that's Fort Worth, Texas. And they were prosecuting him for DWI, and he was looking to get 25 to life. And they said, he doesn't drink anymore, but it's just harassment. And I said, okay. So we did up the habeas corpus, and I went there with the mother and the aunt. And when I arrived at that courtroom where his case was in that court, but this was not a hearing for him. I was just arriving out of the blue with the mother and the aunt. And the place was packed. I mean, we're talking standing room only in the audience area. Scads of attorneys running back and forth. Lots of police officers. The jury box is filled with attorneys that are waiting to do their thing. And so I went to the communion rail and I started to open it. Well, the bailiff was on me immediately. And he says, you can't come in here. And I said, well, I need to get this to the judge. And he said, okay, well, I'll take it to the judge. So he takes the copy of the habeas corpus to the judge. Judge looks at it, looks at me, looks at this. He gives it back to the bailiff and says something to her. Bailiff comes back to me, and the bailiff says, you're not an attorney, you have no right to do this, and you need to go home, or whatever, something to that effect. You know, and he said, get yourself an attorney. And so I leave the courtroom, and the way these courtrooms are set up, there's a clerk's area beside every courtroom. So I go to the clerk's area, and the clerk comes to the counter, and I had the Texas criminal codes with me, and so I opened it to Chapter 11, which is the habeas corpus, and I turned it around for the clerk to see, and I said, see this here? It says that anyone can present a petition for habeas corpus. I said, that guy on the bench in the next room doesn't know the law. He's incompetent. Who's his boss? And the clerk is terrified. And it was like deer in the headlights. And all the other clerks gathered around. And I said, that guy is incompetent. He is working against the law, and so on and so forth. I want him removed from the bench. And I said, I want this habeas corpus filed. And they were like terrified. And I still wasn't making headway with them. So I went to the elevator and I went up to another area. And there was a judge that I'd been in his courtroom before. And the bailiff tried to block me. I got past the bailiff, and I got the habeas corpus into the judge's hands. And this one wasn't the same as others, okay? And he said, Mr. Fox, he says, I know that you have a heart as big as Texas, and you like to help everybody. He said, but you could get yourself into some real trouble with this. I didn't want to confront him with, well, you're a dumbass, and, and the law book says anyone can present a habeas corpus. And the mother and the aunt, they don't know, and they were distraught. And so I went back to the original clerks and raised hell with them again. Still, it was still a problem, and but they did take the document, and we went home, and it would appear that nothing was going to happen. So I did up some other stuff and sent it to Ron in the jail. I believe it was to disqualify the judge for gross incompetence and criminal act, obstruction of justice and all that stuff. And Ron gets this stuff from me, and he's sitting there in the bunk, and he's also got something from the court. And he doesn't know exactly what to do, because the thing from the court is setting a date and time for the habeas corpus. And so he went ahead and sent this thing in anyway, which was just a ferocious attack on the judge. Date and time comes up, the mother and the aunt, we go to the courthouse. So we approach the courtroom door, and it's locked. And the bailiff is standing in the hallway, and the bailiff says, are you here for the habeas corpus hearing? And we said, yes. And the bailiff said, there ain't gonna be a habeas corpus hearing. That case is dismissed. When they looked at between the habeas corpus and the other stuff about criminal acts on the part of the judge, it was like, we don't want to talk about this anymore. That's it. That's enough. You know, because the law book said what it said, which I could present the habeas corpus from the beginning. And this idiot had told me, kiss off and get an attorney.
How long before the hearing was set from the date that you gave them that?
It was pretty quick. I don't recall exactly, but I don't think it was anything much more than a week. It might have been 2 or 3 days. Probably about 3 days, I think.
Okay, so with the habeas corpus, you said anyone can do one, so to get it notarized, I can notarize it with my name on it for someone else, right?
Right.
Okay. What about,
Well, who's making the application for it?
pardon me?
Okay.
She would, I think, she does.
She would for her son.
Affidavit.
Yeah, for my son.
Okay, well, your son is in jail.
Yes. Prison.
But prison. He has to, if either you're doing the habeas corpus or he's doing it, which is it?
We done it together. I gave him stuff to study, and I sent him a copy of yours. Remember, I called and asked you if I could send the copy.
Right.
So he looked at yours. I sent him a Uniform Commercial Codes book and different things that he could study. And so then he put things in, and then basically, mostly I was typing and coaching him along through doing it so that it would be pretty much his work. So then I have a copy of him writing out what he wanted in there, and then I've typed it up and prepared it. And when I went to a notary before with an affidavit, they said that to notarize it, it could not be his name, even though I have power of attorney to handle all of his business. So I wasn't certain about if I can sign my name and be okay with that, being power of attorney, or can I sign his name?
If it's your name, the habeas corpus has to be styled with XREL, you on behalf of the state, for...
With my name at the top instead of his? Like the state, my name?
Yes.
Instead of his
See,
name and state?
habeas corpus, this is, for those who are new to this thing, habeas corpus in a criminal case is actually civil. The habeas corpus is civil. It can be injected into a criminal case, and when it is, it reverses the parties, because Pennsylvania,
Where I'm from?
where he's in prison,
He's in Pekin, Illinois.
Illinois. Okay, so he's in prison in Illinois, and it would be state of Illinois versus our guy, okay? That's the way his criminal case is running. When it comes to the habeas corpus, it's XREL, if it's her or anyone else, XREL on behalf of the state of Illinois for him versus the warden. And it's like a reversal. So he's up here as the plaintiff, and the state is down here as the defendant. And that is a powerful change in terms of status and what's going on here.
So if I'm, make sure I understand you, if I'm doing it XREL, it's me versus Pekin, Illinois, or it's him versus Pekin, Illinois, and then me, XREL, is somewhere at the bottom?
Okay.
You see how you set them up like this? It's always this and that, this versus that.
I can show you exactly, probably with the stuff I've got in the computer, after when this ends here. We'll do that. And if I can't find it in the computer here, I can either write it out for you or send it to you, one or the other. We'll figure it out.
Sounds to me too.
Of course, make a note of it.
Yeah, same here.
Thanks, Rob.
Just send it
Hey,
to
send the
everybody.
whole bit.
Send everything. Listen, if you were sentenced to read the whole thing, you wouldn't have a smile on your face.
All right, any more questions?
Got another question here.
No ex-parte needed.
This is for, this is a complaint. Yeah, this is a civil rights complaint, but it's not habeas corpus. No, it's not habeas corpus. Yeah, this is a civil rights complaint, that's different than a habeas corpus. What else? I should explain for the newbies that habeas corpus can be used for a lot of different things. The system uses it to move prisoners around. Like, say, you might be in prison in Phoenix, and they want you for a trial, to testify in a trial in Tucson. They'll use a habeas corpus to get you out of the prison in Phoenix and get you down to Tucson. Now, from the prisoner's side, it can be used, and it's typically used, to challenge their authority, to have you incarcerated, that you may be innocent, and so on and so forth. But it can also be used, like, say, they deny you your heart medication, or the guards are beating you up, or something like that. You can raise those issues in habeas corpus. It's considered an emergency deal. We do not make the writ of habeas corpus. What we do is make a petition for writ of habeas corpus. And then what I do is put with the petition the order granting for the judge's signature, and also the writ of habeas corpus itself, which is not by my signature, but by the judge's signature. But I've got the thing prepared for him. And it was when I made the shift to that, I started having a lot more success with habeas corpus.
He didn't have to do any work, obviously, so he just signed it.
Right.
Would you include in your emails some examples of orders presented to the judge?
Yeah, that goes right with the habeas corpus.
Make a note of it.
Yeah. I just, it's a matter of routine with me. So the main document that I do is petition for writ of habeas corpus, but I attach to it the order granting the writ, and then the writ itself. Those 2 pages, 1 page each, for the judge's signature.
A lot of times, if we go in and put in a final motion for decision, we want to include an order with that decision that we're asking him to make, instead of waiting for the attorney or for him to write it up.
Right.
We want to tell him what we want done. So, do you have any examples of just writing different orders?
For the habeas corpus, I do.
Okay.
For some other things I may or may not, I can't recall.
trustee sale coming up, let's say in less than a week, how would you handle that? It's a foreclosure.
Oh, man.
You got your notice with you?
Oh, no, I'm not.
You want to come up to the microphone, Carla? Carla's the ace on this one. I can tell by your smile.
There is so much you can do. It's like, where do you start? First of all, on your notice, did it have a statement like on the second page? It says this is an attempt to collect the debt from a debt collector. Was that on there?
I think I don't have it on me, but I think it was on there.
Was it the full paragraph or was it just that? Did it say you have 30 days to dispute this debt? It may not have. It may not have. You can write back to them and request validation of the debt. They have to stop it. There's also things like. Yeah, I stopped one last week, twice. There's a lot you can do. They have to post notices on your property, all the mails, and the notice has to contain certain things. The mail that they give you has to be certified. There's like 100 different things that they have to do. They're easy to stop.
If you look at your deed of trust, okay, in your deed of trust that you signed, it tells you exactly what they have to do to properly notify you of a default. And about 90% of them in Arizona do not do that. So if you find any error there, just say you didn't comply with deed of trust. This is an error. I wouldn't tell them what they didn't comply with. I could say it's not in compliance with the deed of trust.
And the deed of trust.
You have copies. You signed. I'm sorry, no. Don't you have a deed of trust?
Yeah, I have.
Well, read your deed of trust. There's a section in there that talks about foreclosures.
The deed of trust may also not be valid. The last one that I saw, there was an acknowledgement with it. Actually, there was, but it was dated before the deed was even made, so it's void. By law, they cannot foreclose. They have no document. They have no deed of trust to foreclose with until after 10 years. The notary defect or the acknowledgement defect has to be corrected. If it's not, they can proceed after a 10-year period. It will be deemed as if it was okay all along. But with this particular deed of trust, they have to have a deed of trust to foreclose with. But it has to be acknowledged. There's certain things that it has to have, and if it doesn't have it, they have no deed of trust to foreclose with. Anyway, there's a lot you can do.
They have to have the deed of trust there when they foreclose.
Well, they say they're supposed to have it, right?
Wait, so you gotta bring it up.
Right.
You can also do the agency power of attorney thing. Get that. But I would start with the Fair Debt Collection Practices Act, or in just the basic elements of the notice and how they have to notice you. There's a lot with that. I'll talk to you after if you want.
Okay. Tape has 8 minutes left maximum, so.
Well, if there's no more questions at the moment.
Robert, I got one.
Oh, okay.
Quick, one real quick. Real quick. Is this on? No, I turned it off. Carly, you never leave it alone. Anyway, one quick thing. Magistrate judge. Is that an attorney?
Well, he'll be an attorney, all right.
Okay, so if he does not have his bar number on here, this is invalid search warrant? Is that what this is?
On the indictments, that would be the
Not quite
case.
that
This
far
is a
yet.
search
We
warrant.
don't want to get that far.
Huh? This is, yeah, you don't want to get as far as an indictment. You understand that process. What I need to do is send maybe you or everybody the stuff on the letter to send to the U.S. Attorney.
Yeah, I would like that too.
Noted that.
I make a note.
Note that too.
Just sign everything.
Need another notepad?
I got an extra notepad here. Good team here.
Please stop me from the tape runs. I don't want to put another one in.
All right. So before you guys leave, it's been suggested that if you want to get a set of DVDs, you may want to check with Susie so she makes a note of that. And make a note of that.
My real quick question. Assistant of counsel, does that give us the permission to speak if I was an assistant of counsel?
That's gonna depend on the judge. Typically, they'll say no, but I was in a situation with a woman who was, I think, around 78 years old, and she was like shaking, and she turned to me and she said, "Robert, can you help me?" And I stood up and said to the judge, "The woman's 78 years old. She could have a heart attack over this thing. She's so stressed out she can't function, Judge. But I'm familiar with the matter. Would it be okay if I helped her out?" And the judge said, "Very well, Mr. Fox, you can help out." And then I launched such an attack on the attorney. It was like choking people.
Do we get a copy of that too?
I wish I had that.
Try to end that.
Of course, we're going to take it.
We were going on 5:30 and we only have 4 minutes left of the tape.
Right.
So
We're coming to the end, so you got something to say?
They're kicking us out.
Yes, I was going to say, if you want to stay and talk to people or whatever, but we're going to shut down the tape. Because we only have 4 minutes left, so.
Okay.
We can adjourn the meeting and.
Did everyone enjoy the thing?
When's the next one?
What was the question? Fade out, do a nice fade out.
But wait, before, is the thing still running?
Yes.
Okay, I want to say something. You are a wonderful bunch of people. I've been thanking Susie and Ron for inviting me out here, and I think we've made some connections here that hopefully we'll be in touch for years to come and always be friends.
Great. Thank you.
I'd like to thank you for coming out and opening an invitation to my home for you, along with your Texas computer.
Conditional acceptance.
And I'd be glad to work with you for a week or so to maybe get this stuff to a point where it's a little bit easier for you to present it.
Okay.
And maybe slide presentations or PowerPoints or whatever you want in order to make this a more successful project for you.
I want to keep in touch with you too, Mike.
Thank you.
So, yeah, appreciate it.
One last question. What does your wife think of all this?
Which one?
My wife,
He is cruel. He is cruel.
my wife left because she felt that she'd be killed when they come to murder me. And I'm not kidding about that.
We understand. That's a tough
My wife
life.
thinks the same thing. I can't get mine to leave.
Well, start a lawsuit against the government.
Yeah.